The Power and Independence of the Federal Reserve, Point 12, Chapter 5, page 104. Pointed to their posts by the President confirmed by the U.S. Senate, part of the problem of the original Federal Reserve System was, and is, the same one Begot described, with the counterfactual Bank of England, or a mini-reserve system. Nobody would understand it. Esselstyn deserved credit for mostly successful attempt to simplify the Fed's governance structure, but he didn't succeed entirely. The 12 reserve banks, despite owning their existence to a historical compromise that few understand and fewer can explain, continue among us. This chapter takes up the question of how we could understand these instructions as a matter of governance. Constitutional law, public policy, and congressional politics, a lack of public understanding of a confused governance structure is problematic enough. The structure may also be unconstitutional. While assessing that constitutional claim is the focus of most of this chapter, we will also explore whether the commonly proposed benefits of the hybrid governance structure bear up under examination, and why the present system has endured so long. A lack of public understanding of a confused governance structure is problematic enough. The structure may also be unconstitutional. While assessing that constitutional claim is the focus of most of this chapter, we will also explore whether the commonly purposed benefits of the hybrid governance structure bear up under examination, and why the present system has endured so long despite its obvious defects. What are the Federal Reserve Banks? What exactly are the Federal Reserve Banks? The question is easier to ask than to answer. The Federal Reserve Banks have always evaded easy definition, in a large part because they began their lives as private corporations roughly dedicated to a public function, and have become over time more and more like public regulatory institutions in the process. They have retained elements of both public agencies and private corporations. Legally, the Federal Reserve Banks are private corporations chartered under federal law. They have stockholders, the private commercial banks like Wells Fargo, Citigroup, and like that. The banks that join the Federal Reserve System must buy stock in the reserve banks and in turn receive a dividend set by statute at 6%. Those private bank stockholders also elect 2/3 of the members of the Reserve Bank's board of directors. Each board is divided into 3 classes. Class A, directors of stockholder banks, bankers selected by the stockholder banks. Class B, directors are non-bankers selected by stockholder banks. And Class C, directors are non-bankers selected by the Fed's Board of Governors in Washington. Until 2010, the directors voted as a whole to select the Reserve's bank president. After the Dodd-Frank Act of 2010, only Class B and C directors take that vote, which is in turn reviewable by the Board of Governors. Even with the Dodd-Frank charge and the voting process, it is unclear whether the Class A director, that is, the private commercial bankers elected by private commercial bankers, still participate in the vetting and selection discussions of the Fed's personnel. Also under statute, all the directors from all classes vote together to fire the president of the local Federal Reserve Bank for any reason they deem necessary. The Board of Directors under the Federal Reserve Act is required to perform the duties usually appertaining to the office of directors of banking associations, and all such duties are prescribed as by law. Beyond the election of the directors and the directors' selection of the Federal Reserve Bank president, though the idea that commercial banks function as reserve banks, private stockholders doesn't really fit. The banks can purchase only so many reserve bank shares, and they can't sell that stock to others. If the reserve banks are ever liquidated as federal bank corporations, the surplus goes to the U.S. government, not to the banks. In these senses, the reserve banks remain, much like Federal Reserve System generally, creatures of statute, not of private contract. The form of ownership is important, though. It is this corporate structure that leads to accusations that the Federal Reserve System is owned by the banks it regulates. But with the crucial exception of the appointment and removal of the Federal Reserve Bank president, Much more on that below. This critique is overstated. If they are not private corporations, neither are they purely government agencies. In 1952, when the Congressman Wright Patman, a perennial scourge of the Federal Reserve System during his 50 years of service in the House of Representatives, about the legal status of the Federal Reserve Bank, the newly appointed Fed Chairman William McChesney Martin wouldn't give a straight answer. According to Martin, there were corporate instrumentalities of the federal government created by Congress for the performance of governmental functions. The Reserve Bank presidents, in a joint statement in response to the same question, said that they were government instrumentalities, not government agencies, meaning that they were partially part of a private economy and are part of functioning of the government. Although the technically a part of the government, this ambiguity allowed the banks to let the public interest be dominant in their policies, even as they maintained their private independence. In the confusingly legalistic language of corporate instrumentality or government instrumentality, and partially part. And although not technically, we get a sense that nobody knew exactly how to define these strange quasi-private, quasi-public structures. Quasi or quasi. This public-private ambiguity has been the source of extraordinary controversy over the course of the Fed's history. The Reserve Banks and the President, the Fed's constitutional problem. This definitional problem also has constitutional implications. As Patman, the congressionally gadfly of the Federal Reserve, put it in a slight acquaintance with the American constitutional theory of practice, demonstrates that constitutionally the Federal Reserve is a pretty queer duck. I'd go further. As far as the governance of the Federal Reserve banks are concerned, the Fed is outside the constitutional framework entirely. If we cannot quite determine whether the Federal Reserve banks are public or private, political control over the functions they perform also becomes confused. To answer the constitutional question, we must begin with the somewhat curious approach that courts and lawyers take when analyzing the institutional design of governmental agencies. For almost a century, the Supreme Court has staked limits to congressional experimentation. In the staffing of governmental agencies, most of the judicial and scholarly focus has been on how independent from the President Congress can make the leadership of new agencies. A word of caution is appropriate here. As with the Ulysses Punchbowl approach to central bank independence, useless agency independence means something very specific in the legal, referring to the agencies headed by the officials that the president may not remove without cause. Such agencies are the definition independent agencies. All other agencies are not. Thus, agency independence, in the standard sense, is the narrower than Ulysses Punchbowl approach. It refers only to whether the president can freely fire the person or persons in charge of the agency. Of course, one legal feature is not enough to tell us much about the operational independence of agency, including and perhaps especially the Federal Reserve. Because of the narrowness, there is near scholarly unanimity that the removability focus is something of a fetish. One of the main arguments in this book is that independence as an analytical category isn't a very useful one, largely because it is too narrow and legalistic. Even so, as the Supreme Court has explained, the question of who has the constitutional authority to appoint senior governmental officials isn't simply a question or etiquette or protocol. Ensuring that the most important officials of the United States government, including members of the Federal Open Market Committee, conform the requirements of the public accountability of the appointments level is among the significant structural safeguards of the constitutional scheme. And when we make that constitutional inquiry about the Fed, we learn something important as presently designed, the reserve banks are almost certainly unconstitutional. The legal doctrine, appointments, and removability. To understand why we need to get a better sense of legal doctrine, as it starts in the U.S. Constitutional and has been developed by courts, Article 2, Section 2, Clause 2 of the Constitution. Requires officers of the United States to be appointed by the President with the Senate's advice and consent. If Congress wants to set it up, a bureau of agency department staffed by an officer of the United States presidential appointment. The Senate confirmation is the required constitutional minimum, but there's an exception written in the Constitution itself for inferior officers. In those cases, Congress may vest in the President alone, in the courts of law, or in the heads of departments. The appointment of the inferior officers. The first question is determining the constitutionality of an appointment process is whether the officer in question here, the heads of the Federal Reserve banks, are principal or inferior. Officers, because the Constitutional doesn't define the term, the Supreme Court has had access. Different officers are a case-by-case basis. For example, in Morrison v. Olson, a case we'll revisit in a moment, by the court had to decide whether an independent prosecutor, one appointed by the Attorney General to investigate the U.S. President, was principal or inferior. The prosecutor wielded a staggering amount of authority. To investigate the President and his subordinates, but was not appointed as a principal officer under the Appointments Clause. Despite the prosecutor's power to investigate his own boss, the court concluded that the prosecutor was still an inferior officer, and therefore could be appointed by the head of the department, in his case the Attorney General. The distinguishing factor in Morrison was the appointment was relatively short, limited in scope, and importantly could still be ended by a superior who was a principal officer. Again, the Attorney General at the court put it in a later case, whether one is inferior officer or depends on whether he has a superior. Moreover, inferior officers are officers whose work is directed and supervised at some level by officers appointed by the President and confirmed by the Senate. If a federal officer has a boss who went through the presidential appointment and Senate confirmation process, that officer is by definition an inferior one. The first constitutional question we must tackle then is to determine how the Federal Reserve Bank presidents are appointed, and whether in their roles on the FOMC they have a boss subject to the Appointments Clause. There is a second question, which looks not at the Appointments Clause but the general principle, a separation of powers that underlies the constitutional scheme everywhere. And that question deals with not how officers are appointed, but how they are fired. This principle is familiar from the grade school civics. We have three branches of government: executive, the President, legislative, Congress, and judicial. The courts, the President executive function is defined in the Constitutional. He must take care that the laws be faithfully executed. He is one person, but his administration is legion. Hence the need to appoint officers, principal and inferior, to do the work of the presidential administration. We have already discussed some legal restrictions on how these officials with the administration get their jobs. The separation of powers question concerns who gets to decide when and how they are held accountable if they pursue policies inconsistent with the public good. The main democratic mechanism for that kind of accountability is political pressure on the president to defend or fire an official in his government for his policies. If one of the president's appointees is running federal policy in a way that citizens finds inappropriate, he could raise hell until the buck eventually stops at the president's desk and force the president to confront his personal strategy and decision he makes. Either way will have consequences for the president's re-election or legacy. Congress, however, has sometimes sought to control the appointment process more robustly than merely making a political stink about executive personnel decisions. This is where the separation of the powers comes into play. At what point does congressional meddling with the appointment and removal power an unconstitutional invasion of the executive function? The Supreme Court encountered this very issue in 1926. Congress had passed a statute that subjected the appointment of postmasters, historically a very important part of presidential patronage, to the usual advice and consent of the Senate, but also subjected the removal of the postmaster to the same restriction. That is, if the president wanted to fire a postmaster, he needed the Senate's advice and consent. And Myers v. United States Chief Justice William Howard Taft reviewed the statute and concluded it was a bridge too far. Chief Justice Taft's opinion, one he was uniquely qualified to give as only former president to serve on the Supreme Court, concluded that the president must have more authority to determine who could or could not continue to represent him to the American people. The president must have some power over removing those for whom he cannot continue to be responsible. As a result, this particular form of congressional meddling in the officer removal process was declared unconstitutional. It might have been thought, in fact, that any such restriction would run afoul. On the same principle, 10 years later, however, the court retreated from this view. In Humphrey's Executor v. United States, the court confronted a situation where the president, Franklin Roosevelt, fired the head of the independent agency for purely policy reasons, despite his statutory probation from doing so. The problem was William Humphrey, a commissioner of the Federal Trade Commission who was notorious anti-New Dealer, who loathed the newly elected Roosevelt. At the first, FDR tried to persuade Humphrey to do the honorable thing. You will, I know, realize that I do not feel that your mind and my mind go along together, the president wrote on the commissioner, and frankly I think it is the best for the people of this country that I should have a full confidence. But Humphrey wouldn't budge. He wouldn't be talked down from his perch inside a government he plainly detested, and so for FDR fired him by letter effective as this date. You are hereby removed from the office of Commissioner of the Federal Trade Commission. Humphrey sued, and after he died, his estate continued the litigation, hence the petitioner's name, Humphrey's Executor. Humphrey's argument was a winning one. From the statutory perspective, when Congress had set up the FTC, it specifically protected its commissioners from being arbitrarily dismissed. They could be fired for inefficiency, neglect, or duty of malfeasance. Humphrey had been guilty of disagreeing with the president on federal policy, not of any of these other derelictions. From a constitutional perspective, though, Humphrey looked on much shakier ground. The court had already nixed this provision from an earlier statute, giving the president more control over his administration's personnel, and of course, Myers suggested that the president could fire whom he pleased. Congress's role was not to dictate an administration's personal policy. This time, however, the Supreme Court didn't agree with that constitutional analysis and unanimously ruled against the Roosevelt administration. Congress could limit the president's hand in removing federal officers. The court reasoned for independent agencies only for executive agencies were such restrictions illegitimate. The difference was in the nature of these agencies. For the independent agencies, those tasks were different. An independent commission like the FTC was to be nonpartisan. and it must, from the very nature of its duties, act with entire impartiality. The court reasoned such an agency's functions are neither political nor executive, but predominantly quasi-judicial and quasi-legislative, with members called upon to exercise the trained judgment of a body of experts appointed by law and informed by experience. As a result of Humphrey's executor, these statutory restrictions on a president's ability to fire his appointees became the definitional hallmark of agency's independence. For the rest of the 20th century, the court kept this principle in place, expanding in some places, limiting in others. In Morrison v. Olson, as discussed above, 1988 case about the independent counsel, that explains the difference between principal and inferior officers. The court confronted a different kind of statutory restriction, removal protection, not for the head of the quasi-legislative or quasi-judicial commission, but inside the executive itself. In that case, the Department of Justice, the court concluded the Congress gave the Attorney General an officer directly responsible to the President several means of supervising or controlling the independent counsel, including the ability to remove the counsel for good cause. There was thus no constitutional problem with the arrangement. In 2010, in the Free Enterprise Fund v. Public Company Accounting Oversight Board of the Supreme Court confronted the combination of Humphrey's executor and Morrison. What one judge called Humphrey's executor squared agencies' heads the president cannot fire except for good cause and free enterprise fund. The commissioners of the Securities Exchange Commission, who in turn cannot fire their subordinates except for good cause. Here, members of the Public Company Accounting Oversight Board. The court held that such multi-level protection from removal is contrary to Article 2's vesting of executive power in the President, and thus inconsistent with constitutional principles of separation of powers. 2 levels of firing restrictions are one too many. To sum up the state of the law as of 2010, principal officers of the federal government need a presidential nomination and Senate's advice and constant consent to be consistent with the Appointments Clause. Inferior officers can be appointed by the governmental officials, including the heads of departments, separate from the Appointments Clause. Principles of separation of powers, regulative congressional ability to protect a federal officer from at-will employment termination. Congress can insulate an officer from getting fired by the President or the President's representative for any or no reason, but there is a limit. No nesting of such protections is allowed. Layers of bureaucrats cannot become entrenched from presidential supervision like so many Russian dolls. The Reserve Bank's unconstitutional appointees process. How then do the Reserve Banks fit within the constitutional system? To answer the question, we must consider again the circuitously designed Federal Open Market Committee, FOMC. As we saw in Chapter 1, Congress created the Federal Open Market Committee in 1933. As the Federal Reserve System Monetary Policy Committee, the institutional effort was to centralize what had been the quasi-autonomous monetary policies of the 12 reserve banks themselves, created under the original Federal Reserve Act of 1913. 2 years later, in the Banking Act of 1935, 2 years later would be 1915, but here we go. In the Banking Act of 1935, Congress refashioned the FOMC to include all 7 members of the newly created Board of Governors of the Federal Reserve System. Post-1935, the FOMC was made up of 5 of the 12 Reserve Bank presidents on a rotating basis. After 1942, the president of the Federal Reserve Board Bank of the New York became a permanent member of the FOMC by convention but not statute. He is also a vice chair of the committee. The committee meets 8 times per year to announce its outlook on the global and national economy and its decisions regarding various features of monetary policy. It is the president's presence of the reserve banks on the FOMC and the fact that the president has nothing to do with their appointment or removal that creates constitutional problems, both with respect to the appointments clause on the one hand and the separation of powers on the other. First, on appointments, the Reserve Bank's presidents are unconstitutionally appointed whether they are principal or inferior officers in their rotating capacity of members of the FOMC. They certainly look like the principal officers, as the Supreme Court has interpreted that term. That's because they aren't supervised by anyone on the FOMC. As members of the Committee, Reserve Bank presidents' voters count the same as those of their would-be superiors. The president's appointed Senate-confirmed board governors. Indeed, again, it is the New York Fed president who sits in the second chair of the FOMC. If anything, he is supervising the board of governors, not the other way around. But even if the Reserve Bank's presidents were inferior officers, the Constitution doesn't give Congress free rein on those appointments. An inferior officer has to be appointed by the president alone, the courts of law, or the heads of departments. The Reserve Bank boards of directors, those in charge of the president's appointments, are neither courts nor law nor heads of departments, and the president has nothing to do with the appointment of the bank's presidents. As discussed above, the Reserve Bank presidents are appointed by 2/3 of the bank directors, subject to approval of the Board of Governors. The president never formally indicates any preference for their appointment to their posts at the reserve banks. Second, the Federal Reserve Bank also fail on the separation of powers removability. Question: just as the president has no authority to appoint the reserve banks, he has no authority to remove them. The Reserve Bank presidents are removable at the pleasure of the Reserve Bank directors. From all these classes, note that while the Dodd-Frank Act of 2010 took the bankers on the Reserve Bank boards out of the business of appointing the Reserve Bank presidents, the act did nothing about the bankers' ability to fire those presidents. The Board of Governors could fire the Reserve Bank directors, but only after the cause of such removal. Fourth, with the communicated in writing by the Board of Governors of the Federal Reserve System to be the removed officer or director and to said bank. That takes us to the Board of Governors. The President can also fire the board members only for cause, meaning generally the Humphreys executor limitation to inefficiency, neglect of duty, or malfeasance. If this all seems very confusing, that confusion is part of the constitutional problem. Let's take an example. Suppose the U.S. President does not like the way that the President of the New York Fed has been voting on the FOMC. To fire him, the President must do the following. 1. Ask the Board of Governors to fire the New York Fed President, instructing them that he will deem their failure to comply with the request as cause for their own termination. The President must send this message not to the chair alone, but to all 7 governors. 2. The governors must then turn the New York Fed's directors and say that they themselves will be removed if they fail to fire the Reserve Bank president, as the U.S. President requested. 3. The New York Fed's directors, all 3 classes, including the 2 put there by private bankers, would then have to fire the Reserve Bank president, who is removable at the pleasure of the board. The bankers' representatives would have to agree that the Reserve Bank president's failure to honor the U.S. president's policies, not their own, was sufficient for the Reserve Bank's president's removal. It is precisely this kind of nesting of removal restrictions that the Supreme Court has held violates the Constitution. The President cannot remove bank president members of the FOMC without reaching through 2 explicit for cause removal restrictions. On the top of the 3rd layer of at-will removability from the U.S. President to the Board of Governors, Layer 1, the Reserve Bank Board of Directors, Layer 2, to the Reserve Bank President, Layer 3, if the PCAOB, Public Company Accounting Oversight Board, was Humphreys squared, then the FOMC may be Humphreys cubed. Of course, the relationship between the 3 layers in the FOMC and the 2 in Section SEC/PCAOB are different. The Reserve Bank's presidents and the governors are colleagues on the FOMC. Rather than separate ostensibly hierarchical hierarchies, entities, to the extent that the difference matters. It only makes the Reserve Bank's constitutional difficulties worse. For these reasons, the Reserve Banks and the FOMC are currently governed and unconstitutional, and separation between U.S. President and the Reserve Bank presidents is simply too great. The declining significance of the Board of Governors, because the FOMC votes by a majority on the Board of Governors, have a statutory 7 to 5 majority. It's tempting to think this doesn't matter. In fact, a high turnover rate and a presidential failure to reappoint governors means that the statutory majority for the governors isn't as ironclad as it seems. Figure 5.1 shows the percent of time governors enjoyed a majority of the Federal Reserve Open Market Committee by President Soros Board of Governors of the U.S. Federal Reserve System. Roosevelt, Truman, Eisenhower, Kennedy, Johnson, Nixon, Ford, Carter, Reagan, Bush 1, Clinton, Bush 2, Obama. On a scale chart, a graph of 0 to 100. Historical trend after the newly created Board of Governors slowly displaced and abolished Federal Reserve Board. During the last 10 years of the Roosevelt administration, the governments enjoyed a majority nearly 100% of the time. From 1945 until 1977, the majority fell to parity. 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 And never lower for 16 days in 32 years. In the Carter administration, things started to slide. Carter's appointees and their predecessors on the board held an FOMC majority about 85% of the time. But that majority was back up above 90% during the 8 years of the Reagan administration. The slow descent began after that, culminating in the Obama administration's abysmal record at 40